Okay, I reckon it's time we get started. Welcome everybody to RNG Technologies webinar on data sovereignty. This is part of our webinar series. We like to do these once or twice a month, so really happy to see all you guys in here with us today. We have Gordon Tan, Managing Director at RNG Technologies, here with us to present this presentation. He's got some good knowledge on what's happening in the space here, so he'll be able to highlight some of the important issues. I'll hand it over to you, Gordon.
Thanks, Ross. Good morning, everyone. How are we today? I hope you are all well. I'm just having a quick look through the attendees list, and I can see there's a few people from different states, but a rainy welcome from Brisbane. Look, I hope to be able to give you a little bit of insight today on data sovereignty, particularly within the not-for-profit sector, which is where we kind of specialise. And we've really been working through these 15-minute CEO or executive level debriefs on the subject. And so what I'm really hoping to do is just not take up too much of your time, but hit on the key points so that you can take something away practical from the session. If you've got any questions, feel free to use the chat box, which I believe you have access to, and Ross will be monitoring that, and we'll probably do questions at the end. So, all right, let's get started. So again, we only have 15 minutes to spend today, so we're going to go through this at a fairly quick pace. What we're going to be talking about first is what is data sovereignty. We're going to talk about Australian privacy principles, APPs, how you protect yourself, what the consequences can potentially be, and really touch on this from a technology standpoint as well, and start talking about, some of the more common cloud providers, and also, what those implications are for you as a not-for-profit organisation. And finally, we'll end with a little bit of Q&A and just a quick snapshot of what RNG Technologies does. So first, we're going to start off by talking a little bit about what data sovereignty is. Well, data sovereignty is actually, fundamentally, it's the concept that information has been created or stored in a digital form, and that data or digital information is subject to the laws of the particular country in which it's located. It's becoming more and more of an issue, and we'll touch on why that is. It's primarily because of the advent of technology such as cloud computing, but it's becoming more and more important in the not-for-profit sector to understand some of the implications of that, and also understand how you can reduce the amount of risk that you have. The background, why the problem exists, fundamentally it's because data is obviously fast becoming the most important part of an organization. And with this digitization of data, as they call it, or taking that data and putting it into an electronic format, it makes it easy to create and easy to duplicate. It also makes it very portable. So there's no longer situations where you have to be within the office. You can now access information from outside of the office or from multiple offices from all across the country. It's been a fundamental source of headaches for management for quite a while. It's how do we manage and maintain that information? How do we control that information in such a free-flowing environment? And really, because of this digitization process, what's actually happened as a result of that is a number of innovative solutions that have kind of spawned up to address this kind of thing. How are we going to manage and manipulate this data? And cloud is probably the one that has made the most compelling case over the last couple of years, and more not-for-profit organizations are really starting to look at that now and trying to understand how that fits into their overall organization. So that's a bit of the background about why this is now coming in and being so relevant. In terms of the legal challenge, so within each country there's a set of information and privacy laws, and fundamentally one of the biggest problems of that is they've generally been designed to historically look after more physical and less information or digital assets, and what that basically means is that they're often very outdated. The Australian Privacy Act is called the APP, And really what that's about is kind of taking into account all of those different areas and presenting that in a way so that you understand what your obligations are. Now the problem with that is that the APP only applies to Australian-based entities. This is an excerpt from the APP, Chapter 8, which is, we'll talk about it in a little bit more detail. But just to read out one of the clauses, it says, before an APP entity discloses personal information to an overseas recipient, the entity must take reasonable steps to ensure that the overseas recipient does not breach the APPs in relation to the information. Long summary of that is basically that, you know, the liability rests on the you as the organization, or us as the organization, to make sure that the provider that we're passing the information to is compliant. The problem in many cases is that, you know, these organizations may or may not be in Australia, and therefore you know, the privacy policy differs. This is actually the Australian Privacy Principles list. Ross will, if you just want to stick the link for that down into the chat for you to reference. The most important one to have a bit of a look at, there's obviously these privacy principles, there's these different ones, but APP 8 is actually the one that's probably most relevant. So I would encourage you to have a bit of a look. We don't have the time to go into a deep dive into specifically what that is, and it's a lot of legal jargon, but fundamentally, this is the one that's probably most relevant, and you need to have a bit of a look at it. It's talking about, you know, that cross-border or international transfer of personal information and why that's relevant. To take one step back, I mean, for anyone that doesn't obviously understand what privacy law is, it's obviously, and I know that most not-for-profit organizations have a pretty good understanding of it, it's really the regulation of that personal information about individuals, so, you know, how that can be collected and stored. And that's not only for government, but it's also for private organizations as well. So I would encourage you to have a bit of a look through there if you want to get a little bit more detail and just specifically, you know, what you need to be kind of abiding by and what you need to be taking into consideration if you are going to store your information outside of Australia, potentially with a cloud service provider that's hosting outside of Australia or something like that. We've touched on this a little bit already, but you know what the government are effectively saying is, look, it's not the technology partner's responsibility to comply with the APP. It's actually yours. And so what that means is basically the risk is something that you take on, and that you're responsible to contractually ensure that your technology partners comply with those APPs. Fundamentally, that's okay, but you know, particularly with the advent of cloud computing technology, sometimes the goals and objectives of these cloud providers are kind of divergent from, you know, what the government's asking. The reason for that is because cloud is designed to be everywhere. It's designed to be highly available. It's designed to have maybe your data spread across multiple, you know, continents even. And this is the kind of thing that you need to understand. It's also built for a low-cost model, and therefore it's designed to be highly efficient. But what we need to be doing as you know, an organization is questioning the rigor at which they're adhering to these kind of standards. This is from another excerpt from the APP, the Office of Australian Information Commissioner. Enter into an enforceable contract arrangement with the overseas recipient to handle the personal information in accordance with the APPs. Again, that's talking about the fact that you need to be ultimately responsible for that. In terms of what the potential consequences are for the sector, so we work with a significant number of not-for-profits in the technology consulting space, helping them with their technology needs. And to be honest, we haven't seen much in the way of you know, tearing up a funding or anything like that. But what we have started to see is the government's stance on this is kind of changing. So in July this year, in July 2014, the Department of Defense actually terminated a $33.5 million contract, and that was because the data that the provider was storing was being stored overseas. Now, these guys were not a not-for-profit, but it highlights the government's stance and the way that they're going to be looking at this moving forward. Ultimately, the government's going to hold you accountable for those breaches, and that's fundamentally the most important thing. What we have encouraged our clients to do is to, if you are getting funding from a particular government body, is to go back to them and actually highlight, what your situation is, or get feedback in terms of what their policy is around data sovereignty. And generally speaking, these days, more and more departments are actually coming out with particular stances. And it does differ from department to department. So we've had some departments come back and say, no, everything has to be within Australia, and some say, look, we're okay with it. And it really does depend on a case-by-case basis, and you really need to go back through your own channels to speak to them about that. To give you a bit of insight into what the current state of play looks like in the space, obviously having your data in Australia is preferable if you can avoid it. However, if you have a look at this list, this is a list of very common cloud-based services that a not-for-profit organisation may use, and the split of data. So if you have a look down the Australian side, you can see a few of the Australian, suppliers here. Microsoft Azure is fairly recent, so they've just moved their or set up a data center here, so that now you can use their cloud services in Australia, and Amazon as well. Some of you will be using AWS, Amazon Web Services, connecting up IaaS, connecting up most not-for-profit organizations are familiar with them. If you're not, I would encourage you to get familiar. They provide discount licensing and services to the sector, and they are also hosted in Australia. We actually partner with them to deliver that. And Xero, a lot of not-for-profits are using that these days. Interestingly, here's the list of all the ones that are hosted overseas, and you may be looking at that list going, okay, well, there's things there that we are using, and that poses a risk area for you. So Office 365 and Google Apps is obviously the most common. Dropbox and OneDrive as well. People are surprised sometimes to learn that those services, if they're using them, are also hosted outside of Australia, and do pose a risk to the organization as well. If you've got other services that you're using and you just want me to give you a yes or a no really quickly, if you write them in the chat, I will endeavor to answer, depending on if I know what the product is or where their data is actually being stored. But feel free to write in the chat if you need. I guess commonly, not-for-profits and the implications. Look, a lot of not-for-profits are using file storage in the cloud. Whether that is full servers or something like Dropbox or Office 365, SharePoint, something like that. So you need to understand that you're therefore implicated, or your data is therefore being stored outside of Australia. And again, you need to reference some of these materials, and also go back to, if again you're getting funding, you need to go back to those funding areas and speak to them about that. Data retention, so there's often legislation, and I'm sure you're familiar with this as well, around how long you need to retain records for or information for, and cloud service providers often don't make that information as readily available, so you need to go back to them with that and communicate that back to them to find out if they are given you the retention that you need to meet your obligations. There's obviously cost implications, and finally, client management systems. So, when we're talking about that, we're talking about things like Salesforce, Microsoft CRM, whatever applications that you're using. Those applications themselves are often the heart of the organization, and you need to make sure that that information is stored within Australia if that's what you need to remain compliant. So that's pretty much our short 15-minute little run-through of data sovereignty. R&G, we're basically an IT consulting company. We work with a number of not-for-profits in the sector. We also have partnered with Connecting Up to deliver their cloud-based services. We service clients Australia-wide. Our head office is in Brisbane here. Look, we'd be more than happy to have a bit of a chat with you if you'd like some more information about any of this. And we're also doing these 15-minute debriefs. We're trying to keep them as short as possible. We're respectful of everyone's time. If you're interested in getting more of these short little snippets on issues that are kind of up and coming in the sector, please feel free to email Ross, and he'll add you to the subscription list for that. Thank you very much for your time, and if you've got any questions, I'd be more than happy to answer them for you.
Thanks very much, Gordon. Like Gordon said, if you have any questions now, just type them into the chat pane, and we can go over them. I'll give you a couple couple of seconds to think about that.
I had a question about Blackboard earlier. If you're using Blackboard, it's US, I believe. But just double check that. Last time I checked it was US. So if you're using any of the Blackboard products, yeah, you will need to go to the US.
Alrighty, doesn't look like we have any questions, so we'll wrap things up, Gordon. Thanks again for your time. I did want to let everybody else know that our next sort of 15-minute debrief for not-for-profits is on December 4th. We're doing one on Skype for Business is launching for NFP, so we're going to have a look at what that means, what's involved, and the changes that are happening with Microsoft Lync and how it is changing to Skype for Business. So I'll include a link to that one along with a webinar recording link and some links to the APP files and web pages in a follow-up email today. Other than that, thanks again for joining us. Gordon, any last words? Or
No. Enjoy the day, everyone.
Okay. Bye for now.